Good morning, everyone. I hope you are all very well. Can you hear me? Put something in the chat. Just let me know that you're there. Great. Thanks very much. And good to see you or kind of be here with you virtually. We are going to be talking today about unfair terms and business, and particularly small business. And the overall question for today is going to be, is fair enterprise possible? So my name is Ewan McGahey. I guess you're watching EwanTube, and I hope it'll be a good lecture today. And I hope that you're all very well and having a good week. So the things that I'd like to start off with today are a couple of cases that one you've already seen and another one that we're going to go into next week. The question that I want to pose is whether the law should control unfair terms, and really to what extent should the law control unfair terms. So the case that you've seen already is called Times Travel and Pakistan International Airlines Corporation. So this is the case on lawful act duress, where, if you remember, the Pakistan Airline Company is a big monopoly supplier of airlines, and a case was brought by some travel agents like Times Travel, who said that the airline corporation was unfairly changing the terms on which it subcontracted flight packages to the travel companies. So the action for lawful act duress failed. But you've learned about that last term. But what I'm interested in is the statement of principle that Lord Hodge puts forward in a majority judgment. So Lord Hodge says the courts have taken the position that it's for Parliament and not the judiciary to regulate inequality of bargaining power, where a person is trading in a manner which is not otherwise contrary to law. He goes on to repeat, there is no doctrine of inequality of bargaining power and no general principle of good faith in contracting in English law. A powerful commercial party, he says, such as a monopoly supplier, can impose onerous terms as a condition for entering into a transaction with another party. And again, this is when Parliament hasn't done something. The message seems to be from Lord Hodge on the Supreme Court that there's just really nothing for the courts to do. It's not our problem, folks. And the second statement from a recent Supreme Court judgment that I want to start with is called Parking I and Beavis in 2015, where Lord Sumption and Lord Neuberger say that for most purposes, what we're going to do today, the Unfair Contract Terms Act of 1977, was superseded by what's now the Consumer Rights Act 2015. So there's really not much role for unfair terms regulation on the view of the Supreme Court when it doesn't affect consumers. So together, these two judgments seem to suggest that judges on the Supreme Court think that when Parliament doesn't do anything, the courts shouldn't do anything about unfair terms. And secondly, that the legislation that we do have is really only for consumers, and the little bits that weren't, parts of the Unfair Contract Term Act that are left and not dealing with consumers in the Consumer Rights Act, well, they should be narrowly construed. That seems to be the implication. So we don't have a general doctrine of regulating bargaining power, and the need for controlling unfair terms for most purposes, in their view, is superseded. Except for consumers. And so the question this leads to is, well, whether fair enterprise is possible in English law, or should it be? And most importantly for today, should we care about small businesses when it comes to unfair terms? And I think that we should. And so this leads me to the three main points that I want to put forward for today. First part of the argument that I'm going to try and persuade you of is that standards to halt unfair terms are needed for small and medium enterprise. It's not just for consumers, which we're going to look at next week, because markets without standards are rigged, or they end up being rigged for big business. It's not really freedom of contract when the strong can push the weak against the wall and impose any terms that they like. And this is also a problem for our courts and something that the court should be dealing with. The second main point is that there are many examples of small business and medium business cases which regulate unfair terms. They aren't superseded, as the Supreme Court seemed to suggest in Obiter Dicta in Parking I and Bevis. And this case law is important, and it shouldn't be minimized or narrowly construed by our judiciary. They should take the Unfair Contract Terms Act that we're going to be looking at seriously. Third point is that unfair contract term regulation sets a baseline within a broader system of fair enterprise, including on public ownership, sectoral regulation, and competition law. And courts just aren't doing their job if they have taken the position that everything should be left for Parliament when it comes to unfair contract term regulation. What the court should instead be doing, if they have a principled approach to the law, is that they should be construing the legislation on unfair terms and the common law and equity in a way that is consistent with the ecosystem of regulation on public ownership, price standards that are fair, competition law, and so forth. And we're just going to be concentrating on the regulation of unfair terms, but I think it's important to see that this is part of a much broader context of regulation, as I say, an ecosystem of regulation that, if it's not succeeding yet, at least is aiming towards trying to get fair enterprise. Okay, so what I'm going to do is go through, first of all, some historical background as usual. Secondly, we're going to look at the basic principles in the Unfair Contract Terms Act, which is focused on regulation of terms, particularly now for small and medium enterprise. And third, we're going to walk through the different sections. We've already seen a little bit on safety and life, protection of life in section 2.1. And we're going to be going through the main ways in which the Unfair Contract Terms Act protects people from unfair terms relating to property damage, breach of contract, and standards in the sale of goods acts that we looked at last week. Okay, so first thing is some background on the idea of fair enterprise and what the law has to do with it. Modern economic laws, contract law reforms, and a few arguments about where reform should go or could go. So the idea of fairness in contract is very old, as we've seen before. Just to recap that the Justinian Code in the later Roman Empire, the Corpus Juris Civilis and the Codex, 534 AD, said that if people sold land for less than half of what it was worth, they had the right to get the land back if they'd been ripped off, and they should receive what is lacking in a fair price. So this is an example of what was actually in the law, and it was theorized by an old, I suppose, theologian, but really lawyer, called Thomas Aquinas in a book called Summa Theologica in the 1200s, that there should be a general idea or a general principle of just prices in commercial relations. Sellers who fail to sell at a just price was, according to Aquinas, pretty much the same thing as deceit or fraud. But the price, or the just price of things, he says, is not fixed with mathematical precision, but depends on a kind of estimate. And I think that's what he's saying, is that the law can't always prescribe in every single example what might or might not be a fair price or a just price. But it could, the law could set boundaries or set ranges of estimates for what could count as fair and unfair prices, and by extension, fair and unfair terms in contracts. And so there's a principle there that he thought was important, that prices should be fair and just. Now, we didn't see very much of this adopted in the common law, but there were examples scattered throughout history. So one of them that we saw briefly before in Carter and Bohme in 1766 is a case where one of the great judges of his age, Lord Mansfield, said that there should be a general principle of good faith or utmost good faith in all contracts. That case was about an insurance contract, but actually, in another case after that called Pawson and Watson, Lord Mansfield argued, well, said in the court, but really it's making an argument, that in commercial law, by the law of merchants, all dealings must be fair and honest, and fraud infects and vitiates every mercantile contract when the terms are not fair and the dealings are not honest. So, almost exactly the same thing as Thomas Aquinas is saying, that failure to be fair is tantamount to fraud or deceit. And not long after, or really around the same time as Lord Mansfield is writing, one of the great economists of modern history, or maybe even the first economist, Adam Smith, in The Wealth of Nations, argued that free markets were a good thing for small businesses of partnerships. The butcher, the baker, and the brewer, if they followed their own self-interest under conditions of competition, then a system of just prices would result. And not very well known, but I haven't got it here. In another book called A Theory of Moral Sentiments, Smith argued that if the markets were led by small partnerships that were highly competitive, then it would result in a system where there would be nearly as the same distribution of the fruits of the earth, nearly the same distribution for everybody as if the earth had been divided into equal proportions. So people like Smith at the time believed that if you set up a process of small partnerships, competitive, freely pursuing their own interests to try and serve customer demand, this would result in a distribution of wealth that was broadly equal, not massive wealth and income inequality that we see across society today. And importantly, Smith believed at the time that all corporations, big joint stock corporations like the Royal African Company, the South Sea Company, the Dutch, or the British East India Company, and these big joint stock corporations that monopolize global trade, that they should all be banned and they should be remain under statutory prohibitions that existed in the 18th century. Because big corporations, when you had directors managing other people's money, were prone to negligence and profusion, carelessness, and a tendency to unjustly enrich themselves at everybody's expense. And he also argued in The Wealth of Nations, often forgotten, that many enterprises, however, could work with government-regulated corporations. So joint stock corporations shouldn't be banned entirely, but there should be exceptions, and there should be public ownership as well of many sectors where things were sort of routine or it was in the general commercial interest. So he pointed to things like banking, insurance, transport, the post office or the Royal Mail. These were things that were apt for public control and regulation. And this idea came into the common law in one notable case in the Chancery Courts called Allnutt and Inglis. Lord Ellenborough said that a warehouse store of the London Dock Corporation is a claim against a warehouse that had a monopoly control of warehouse space in the London docks. Lord Ellenborough says that there was a general principle that every person may fix what price he pleases upon his own property. So if I've got property and I'm selling stuff with it or through it, then there's a general principle that I should be able to fix my own prices and people's access to my property or the services that I'm providing. But if the public have a right to resort to the premises and the person has a monopoly over them, then they must, as an equivalent, in return for the law protecting one's property rights, protecting even monopolies, there must, as an equivalent, be performance of the duty attached to it on reasonable terms. So if you're somebody with a monopoly, then you've got a duty with your property to perform services and provide goods for others on reasonable terms. And so that's a pretty big statement of principle. If we've got competition, right, if we've got competitive markets, then the market should work to ensure fair prices and fair terms for everybody. But the courts are recognizing that sometimes markets don't work. Sometimes there isn't competition. And then the law needs to require fair contract terms and fair prices. So that's what Lord Ellenborough is pointing to. Now, it's just one case, and these are sort of peppered through history. But there's a statement of principle of what the common law and equity could do, and statements of principle which help us to think about what the law might or could be doing today. Now, the courts weren't very active, so over the 19th century, Parliament continually stepped in to ensure that fair contract terms existed for major enterprises that affected many, many people's lives. The Railway Regulation Act of 1844 said that there had to be cheap trains for people who were going to work every day, so 1 penny for working classes who were travelling for their jobs. The Gaswork Clauses Act, providing power and lighting. The gas companies, who often held local monopolies, had to perform their services on fair terms and at fair prices. Same with water companies, for clean drinking water. And these acts also limited dividends that could be paid out by joint stock corporations, so that too much wasn't taken for shareholders at the expense of the public. The Telegraph Act, 1868, nationalised the telegraph companies, and incredibly, through a court case called Attorney General and Edison Telephone Company, the court held that the telegraphs were pretty much the same thing as telephones when they were invented, and that the nationalisation of the telegraphs, or the statute that nationalised the telegraphs, automatically extended to public ownership and control over telephones, as I say, when they were invented a bit later on. There was public ownership of the oil companies, the Anglo-Persian Company, which later became British Petroleum, or BP. 50% stake was bought by the government. The BBC was established, a British Broadcasting Company was established in the 20s. As a public service broadcaster. And so all of these ideas, all of these statutes rather, were driven by ideas of lawyers and political economists who were essentially arguing that if you just leave it to corporations, private enterprise often doesn't work, and so you need public ownership, control, and regulation. A good source, or a good example of this at the time, and there are many, but one of the good ones is by Sidney and Beatrice Webb, who founded the London School of Economics, but Sidney Webb was a law student at King's College London. In a book called Industrial Democracy in 1898, they argued that the whole of the economy is or involves a stream of pressure. We've been doing duress and undue influence previously in the last term, but actually, pressure, and quite often illegitimate pressure, even if it's not unlawful, is the way that much of the economy operates. There's a stream of pressure and systematic unequal bargaining power between manufacturers, suppliers, wholesalers, retailers, and especially putting pressure down on workers at the sort of base of the pyramid of production. Consumers pressure retailers, retailers pressure wholesalers to put prices down, wholesalers pressure manufacturers, and then workers at the bottom. And to try and change a system of coercion in the economy and undue influence and pressure, there should be progressive public ownership of the means of production. So certain key industries should be brought into public ownership. There should be extensive regulation of contracting. And one of the things that they particularly focused on, again, this is 1898, so it's a long time ago, primitive thinking from today's perspective, perhaps, or not as well thought out, rather than primitive, but they particularly believed that it was important that workers are able to get fair wages through collective bargaining. So Sidney and Beatrice Webb's industrial democracy was, one of the drivers of increasing movements toward public ownership and regulation of industry. If we go to the United States, we see a different track or a different trajectory in the way that enterprise law developed. And again, this is part of the battle of trying to get fair contract terms. So in the civil rights cases in 1883 and a notorious decision called Lochner in New York in 1905, the US Supreme Court effectively said it was unconstitutional to have any regulation of contract terms, public ownership, things like that were just going to be unconstitutional according to various bizarre theories that invents out of the Constitution. It said it was a deprivation of liberty to try and regulate contract terms. It was violating due process of law for state governments or even Congress acts to try and pass social and economic rights. And in these two cases, it struck down, first of all, equality and anti-discrimination legislation in the civil rights cases that allowed Black Americans or African Americans to access accommodation or theaters on equal terms to white Americans. It said that it was unconstitutional to have modern civil rights legislation, and that scar on sort of racist history persisted up until the civil rights movement of the 1960s, Martin Luther King Jr.'s March on Washington for Freedom and Jobs. The Lochner era, beginning in Lochner in New York, did pretty much the same thing. This struck down legislation in New York State to regulate extremely long and oppressive working hours of bakers in a shop in New York. Said it was unconstitutional for the legislature to intervene in the contracts between worker and employer. So long story short is that the US Supreme Court said effectively any social and economic rights are unconstitutional. And that was one of the major drivers of the Wall Street crash. Because the courts also struck down Social Security legislation to give people old age pensions. As a result, many Americans had nowhere to save their money except in the stock market. So they put loads and loads of money into the stock market. Over the 1920s, there was an enormous stock market bubble, and all of this ended, again, long story short, without any real financial services regulation or securities regulation. This ended in the Wall Street crash. That led to the Great Depression, because when the stocks crash, nobody's got any investment anymore. Businesses close down, they sack workers. Workers don't have money to buy products and services. This leads to businesses losing even more money, and you get this sort of downward spiral into the Great Depression in the 1930s, made even worse by the Republican President Hoover, who decided this would be a really good time to impose tariffs and lock down international trade. So the economy is left in ruins, and President Roosevelt wins the election at the end of 1932, promising a new deal for America. And one of the first great planks, parts of the New Deal, was what was called the National Industrial Recovery Act of 1933, which proposed codes of fair competition enforceable by the president's executive order. So for fair wages and for fair prices over all kinds of consumer goods, goods and services. The idea was supposed to be that different parts of industry, businesses, consumer groups, workers would get together and agree collectively what codes of fair competition would be, and then the president would give legal authority to these codes through an executive order. But again, this was struck down by a reactionary US Supreme Court in a case called Schechter-Poultry in 1935. It held that it was an unconstitutional delegation of executive authority for the president to have power to enforce codes of fair competition, again halting the experiment. What happened then is that there was another election. President Roosevelt won the 1936 election with an enormous majority. even bigger than the first time. I think it was something like 48 out of 50 states that Roosevelt carried. And the US Supreme Court decided, or one of the members in particular decided, that they would not strike down the New Deal legislation that was going through. Known as the stitch in time that saved the 9 US Supreme Court justices. And of course, we've still got similar problems with the US Supreme Court today, striking down a lot of legislation that the democratically elected part of the Congress that it enacts. Okay, so but what happened then in the sort of second phase of the New Deal is that different kinds of acts of Congress were passed to try and ensure fair competition through new antitrust statutes, prohibiting unfair practices, price discrimination, the Robinson-Pateman Act of 1936. And then, of course, there was, in another story, the resurrection of collective bargaining and fair wages under the National Labour Relations Act of 1935. And all of this went into a new concept of a second Bill of Rights that I spoke to you about in the first lecture. So, there was a different trajectory in the United States. We got more public ownership in Britain and also in continental Europe. In America, there was this attempt at codes of fair competition, and that was struck down, but it was resurrected through piecemeal acts of Parliament. So, in the post-war period, all of this led to, I think, four main ways in which the concept of fair enterprise could be realized. We see this in the UK. So not one answer, but four main things. First of all is that there was increasingly widespread public ownership, like of the central bank, the Bank of England, the National Health Service. So, healthcare was nationalized or socialized. We have socialized medicine to make sure that it's free at the point of use, paid for through progressive taxation. We nationalized the railway companies, buses, electricity, water, to make sure that the essential things in life that we all rely upon are accessible on fair terms and either free at the point of use or at fair prices. Now, a number of these things have been reprivatized, but they're still regulated. So that's the second way in which fair enterprise was realized. We have regulated enterprise with regulators that are capable of fixing prices and contract terms. For instance, on the Office of Rail and Road, so we reprivatized the railways, but railway fares can still be capped, bus prices, potentially, certainly in London. Ofgem regulates gas and electricity markets. Ofwat regulates water prices. And the Office of Students, believe it or not, regulates university tuition fees, for instance. It used to be free, as you might well know, to go to university. And then fees were progressively introduced: £1,000 a year, £3,000 a year, now £9,000 a year, and just unlimited for international students. But there is some residual statutory control that would make it even more expensive. But so all of these are different ways in which terms are regulated for major things in life. Then there's competition law, control of monopolies, control of cartels. And the thing that we want to focus on today is another set of controls for unfair terms. So not just prices, but what happens when the industry in question is not in public ownership and there's not a regulator, and we're not looking at the price in particular, but what about other terms in the contracts that could potentially be unfair? In 1975, the Law Commission produced a report saying that there should be regulation of these subsidiary terms. We're in no doubt, they said, that in many cases, exemption clauses which exclude liability for things that people expect to get in contracts operate against the public interest, and that the prevailing judicial attitude of suspicion or indeed hostility to such clauses is well founded. So think about cases like Ollie and Marlborough Court or Chapperton and Barry, where the debt chair collapses. So there's obviously judicial suspicion of attempts to exclude liability for people being injured or people being not provided with the thing that they reasonably expect in the contract. So judicial suspicion or hostility in the case law is well founded, says the Law Commission, because all too often these exclusion clauses are introduced in a way which results in the party affected by them remaining ignorant of their presence or import until it's too late. That party, even if he knows of the exemption clause, will often be unable to appreciate what he may lose by accepting it. In any case, he may not have sufficient bargaining strength to refuse to accept it. And that's just not good enough, says the Law Commission. There should be more control of unfair, surprising terms by the law. So it goes on to say that the result is that the risk of carelessness or a failure to achieve satisfactory standards of performance is thrown onto the party who is not responsible for it or who's unable to guard against it. Moreover, by excluding liability for carelessness or failure, economic pressure to maintain high standards or performance are reduced. And so that's important, because what it's saying is that this is a general economic problem. If we have businesses that are imposing unfair terms on others, not just consumers, but small or medium enterprises being subjected to unfair terms by big business, or exclusion of liability by big business for things that they would otherwise be expected to do, then standards for good performance in competitive markets are reduced. Because if you can avoid liability for things going wrong, why on earth would you make investments to ensure that your products and your services are to a satisfactory standard? So competitive markets work to an extent, but when people can exclude liability for things that are unexpected, things that don't go wrong often, then that's something that the Law Commission is suggesting isn't often solved by the operation of competitive markets. And so therefore we need legal regulation. There's no doubt that the misuse of these clauses is objectionable. Some are unjustified. Others, however, may operate fairly or unfairly, efficiently or inefficiently, depending on the circumstances. Okay, so exclusion clauses may work sometimes, to be a fair contractual allocation risk, sometimes not. For example, the cost and practicability of insurance may be factors in determining how liability should be apportioned between two contracting parties. So there's not always one answer that the law should give. Maybe we should look at which party is best placed to get insurance. The problem of devising satisfactory methods of controlling the use of these clauses and indeed of identifying some of them has proved both difficult and complicated. So, says the Law Commission, we need to give power to the courts to regulate unfair terms through legislation. And so that is the background and the lead up and the context of the Unfair Contract Terms Act of 1977. Often seen, or what certainly was seen at the time, as the biggest incursion into this old ideal, an increasingly fictitious ideal of freedom of contract. We're going to go through the basic principles now of the Unfair Contract Terms Act. Its scope, the rights that are involved are some of the basics, and the idea of reasonableness that underpins much of the law. So starting point is what the scope of the Unfair Contract Terms Act is, or what it covers. And the answer to that is that Section 1.1 of the Unfair Contract Terms Act says that it's mainly concerned with negligence, or largely concerned with negligence, a few other things, and it defines negligence as the obligation to take reasonable care as an express or implied contract term. So we've already seen that in the Sale of Goods Act 1979, that you've got a duty of to goods of satisfactory quality. So this is the opposite of that. Or in the Supply of Goods and Services Act, you've got to perform services with reasonable care and skill. Negligence is the opposite of reasonable care and skill. If you're not careful, if you're not diligent, you're negligent. And so that's one definition of negligence. Another is the common law duty of care in tort. So if you fail to take reasonable care in tort outside of contract, That's also negligence. And then a statute called the Occupiers Liability Act of 1957 says that if you've got people coming onto your premises, like a supermarket, it's got to be reasonably safe for people who are visiting. And Section 1.3 says that the scope is also business liability. So we're not really concerned about contracts that don't involve businesses and their liability. We're just concerned with people who are operating in the course of business. But the Act also defines this to encompass government or public authorities. So, a local council, some other kind of public body, a central government agency. They're also included in the scope of unfair terms regulation. And so what exemption clauses do, or exclusion clauses do, is that they purport to exclude or limit the implied terms to prevent negligence at common law, in tort, in contract, or in statute. Schedule 1 makes some specific exemptions from this scope. So it's not concerned, the Act is not concerned with contracts over insurance, land, intellectual property companies, or company shares. So securities contracts like bonds and derivatives and so forth. We don't need to worry about those. That's for a course on the financial regulation. So that's the scope. And then our first main section is Section 2.1. We've already seen this, but we'll just go into this in a tiny bit more detail. So Section 2.1 says a person cannot, by reference to any contract term or a notice given to persons generally or to particular persons, exclude or restrict his liability for death or personal injury resulting from negligence. So indirectly what this is doing is it's protecting people's right to life, it's protecting people's right to health and safety. So Section 2.1 very simply is saying if you've got a term that is trying to restrict somebody's liability for negligently harming somebody's life or person, causing personal injury, then you can't have such a term. You can't have a term excluding or restricting such liability. Easy. So if a person would be liable in tort or contract for negligently killing somebody or injuring somebody, they can never exclude liability towards the victim. So if we imagine that we had this section in operation in some past cases, we can play the game of what the outcome would be. So if we look at Thompson and Scottish and Midland Railway, where Mrs. Thompson gets off the train, but unfortunately the train has stopped past the platform and she falls off into the darkness. Could the train company exclude or restrict liability for their negligence in causing Mrs. Thompson's injury? Section 2.1 very simply would say, no, you can't. So Mrs. Thompson would win. If we look at Chapelton and Barry, okay, Mr. Chapelton won in that case, but there would be a much easier route rather than looking at when the term had been incorporated. You could just ask, well, does this purport to exclude or limit liability for personal injury? The answer is yes, and so Section 2.1 says you can't do that anymore. Mr. Thornton in Thornton and Shoe Lane Parking, where the trumpeter is injured after coming back from his performance at Farringdon Hall in Shoe Lane Park, parking the car park, and he's injured. Could the car park exclude or restrict liability for injury there? The answer is no under Section 2.1. Remember, Lord Denning said the notice inside the car park couldn't affect the fact that the contract was already formed when he entered the car park. So the exclusion or restriction was too late. But Section 2.1 also adds that it just wouldn't work whether it was incorporated or not. Whether the notice was at the front of the car park can't operate to exclude or restrict liability for personal injury. You also see the same thing now, by the way, in the Consumer Rights Act, Section 65. So has exactly the same effect as under the Unfair Contract Terms Act for consumers, and we'll do that next week. So the Unfair Contract Terms Act also has Section 6, which relates to the supply of goods and services and the sale of goods legislation that we saw last week. So Section 6.1 of the Unfair Contract Terms Act says that the Sale of Goods Act Section 12 and Section 8 becomes subject to a reasonableness test, sorry, not subject to a reasonableness test, becomes mandatory. So the seller or the hirer of a product has to warrant that they have good title to the thing. So the thing that they're selling or that they're hiring out is theirs to sell. So any clause that purports to exempt liability for this just becomes void. And then Section 6.1a says that exemptions are for the Sale of Goods Act 1979, Sections 13 to 15, or the Supply of Goods Implied Terms Act 1973, Sections 9 to 11, pretty much the same. The goods must match descriptions or samples, or goods must be of satisfactory quality. If we have exemption clauses that try to remove or restrict liability for these implied terms, then they are invalid unless they are found to be reasonable by a court. And we'll get to the reasonableness test in just a second. And we see the same thing for consumers in the Consumer Rights Act, Section 31 next week. So what is this reasonableness test? So you can exclude or restrict liability for these implied terms if it's reasonable. So what makes a contract term reasonable? What makes an exclusion clause or limitation clause reasonable? And there's two provisions here that we need to know. First is Section 11. And Section 11.4 says that in determining whether a clause in a contract is reasonable, we should take into account the resources that one of the parties has, or the defendant has, for liability, and how far it's capable of getting insurance to cover the costs of something going wrong. So which party is better placed to get insurance for the risks in the contract? So this is just one of the factors that we take into account. And the other factors are set out in Schedule 2. It's got a list of 5 things. First, and probably the main thing, is what is the relative bargaining power of the parties. So we've got, if we have a big business dealing with a small business, the big business, by virtue of more resources, more wealth, collective organization, possibly information, the big business has more bargaining power. It's usually a function of size, but so we take that into account, if it's a monopoly or not. If it's two small businesses dealing with each other, well, there's no real difference in bargaining power. If there's two big businesses dealing with each other, again, no real difference in bargaining power. But if there's an imbalance, small business versus large business, then that is relevant to whether the use of the clause is reasonable. Are there alternatives of supply? Can the claimant find another person to get the same product or service from? We take that into account. Is there choice on the market? Are the clauses transparent? Is compliance with conditions practicable? Are the conditions in the contract, is it possible to comply with them? Or are goods made to order? That one usually suggests that, well, if they're made to order, there's been a negotiation over the contract terms. Schedule 2 refers to Sections 6 and 7 in the Unfair Contract Terms Act only, but it's generally accepted by the courts, for instance, in a case called Woodman in Photo Trade Processing, that the courts will take into account not only Section 11, but also all the factors in Schedule 2 in determining what's reasonable underneath all of the provisions of the Unfair Contract Terms Act. So now we see a case illustrating this. We looked at it last week in the story from Lord Denning, and now we'll get to the details of George Mitchell and Finney Lockseeds, the first big case in the Court of Appeal applying the Unfair Contract Terms Act of 1977. So here what happened is that George Mitchell Chester Hall Limited bought cabbage seeds from Finney Lock Seeds. So George Mitchell is a small farmer. And in the contract, the terms for the cabbage seeds in clause 1 said, in clause 2 said that damages for defects in the cabbage seeds were limited to the price of the seeds. So if something goes wrong, if the cabbages don't grow, then you can't get damages for all of the economic losses that flow from the breach of contract. You can get the price back, right? But the problem is for a lot of farmers that they sow the seeds in the land, they wait for months until the harvest comes. And it's only then that you know that the seeds haven't worked, and that ruins. I mean, if the seeds don't work, a whole year's worth of production. So their losses are much bigger. It means that they can't sell and get the profits that they would make from the people who they supply with cabbages. So, obviously, that's what they want to be covered, or the farmers want to be covered. But Finney Lock Seeds is saying, well, no, we're not going to pay for any more than the cost of the seed. So just a refund. So this was the difference between about £200 that Finney Lock Seeds wanted to pay back and £61,000 for George Mitchell. So the question was whether they could do this under the new Unfair Contract Terms Act. In the Court of Appeal, Lord Denning, who was dissenting on the reasoning, held that the limitation clause did encompass the defective cabbages, but was unfair on the Unfair Contract Terms Act, now Section 6 and Schedule 2. Under Section 6, it was actually another statute that has since been reenacted, but it's now Section 6 of the Unfair Contract Terms Act. This purports to restrict liability for defects in the product. So the product is not of satisfactory quality under Section 14 of the Sale of Goods Act. And the Unfair Contract Terms Act, Section 6, says that, you can exclude or restrict liability for satisfactory quality if it's reasonable. And so then we go to Schedule 2 to ask, well, is it reasonable under the Act? So he says that the exclusion was unfair, fails to pass the reasonableness test. He's dissenting on the reasoning in getting to this result because Lord Justice Oliver and Lord Justice Kerr held that the things being sold were not even cabbages. So they held that the limitation was not effective either. But they didn't apply the Act because they said that the cabbage seeds being sold, because they didn't grow into real cabbages, they weren't really cabbage seeds, which is kind of a creative interpretation. Lord Denning says, well, we don't need to do that anymore. I mean, we can just say, without sort of jumping through semantic hoops, in our rules of construction, we can just say that the cabbage seeds were defective and that the limitation or the exclusion was unfair. The House of Lords unanimously upholds Lord Denning's reasoning and result. So everybody's come to the same result, that Finney Lock Seeds can't limit liability. Lord Denning's reasoning is upheld in the House of Lords. The clause did concern cabbage seeds, and what was sold fell within it. And the limitation was unreasonable because the seller, who was dealing with lots of different customers, was in a better position to guard against and ensure the risk of seed failure than any single farmer. So, that's focusing on the test in Section 11. So the point of that is that if I'm a seed company and I'm selling to lots and lots and lots of different farmers, and then you compare that with a farmer who's just buying from one seed company, it's easier for me as the seed company to get one insurance policy to cover the risk of seed failure for all these different contracts than it is for all of these different farmers to get lots and lots and lots of insurance contracts to individually cover the risk of any given seed failure. So who is best placed to get insurance? It's the seed company. They can get one insurance contract, whereas If we said that the risk was placed on the farmers, then you'd have to get lots and lots and lots of insurance contracts, or the farmers would have to get lots and lots of insurance contracts. So that is determinative of whether the clause is reasonable. Lord Bridge says on the reasonableness test that the court has to entertain a whole load of considerations, put them on the scales on one side or another, and at the end of the day decide on which side the balance comes down. So there's not just one factor in the reasonableness test, we weigh them all up. There will sometimes be room for a legitimate difference of judicial opinion on what the answer should be. There's not sort of one right answer. And the appellate court should treat the original decision of the first instance court with the utmost respect. So there should be a certain amount of judicial deference to application by the first instance court, the county court, or the high court, depending on the value of the claim. That there should be judicial deference to what the first instance decides. And so only if there's a sort of serious error, then the appellate court should interfere in what the first instance courts decide. So if we ask, again, playing the game of how old cases would be decided, and we look back at Lestrange and Graucob from our first lecture, and we ask, well, how would it go today? I think the answer is that it will probably be quite different. So, remember there we've got Mrs. Lestrange being sold a cigarette vending machine by Graucob F Limited. And Graucob says the written contract is the entire agreement. There's nothing outside of this agreement. And we exclude liability for defects in the product. If we ask how that would play out under the Unfair Contract Terms Act today, the first thing is that we'd say that they're breaching an implied term of satisfactory quality under the Sale of Goods Act, Section 14. And then they are they're purporting to exclude liability for defects within Section 6 of the Unfair Contract Terms Act. So under Section 6.1a and Section 11 and Schedule 2, we ask, well, is this exclusion clause reasonable? And I think the answer would probably be no. There's an inequality of bargaining power, quite big, between relatively or medium-sized, at least, cigarette vending machine company and the small business of Miss Lestrange, just with her restaurant. So there's an inequality of bargaining power. There's a lack of transparency, perhaps, you might say as well, because it's not really spelt out to Miss Lestrange, except in this written contract terms that lost in the small print, and so the clause would very, very likely be held to be unreasonable. This is also the view of Andrew Burrows, who's now Lord Burrows on the Supreme Court, in his casebook on contract. By the way, we should also ask, under Section 6 and the Consumer Rights Act, Section 2.1, would Miss Lestrange count as a consumer, as we're doing next week? And the answer to that is no. I mean, although she is, she could be just buying this for her own private use, or you could buy a cigarette vending machine for your own private use. I mean, actually, she's a small business, so she doesn't fall within the definition of consumer, and therefore she would still be in the regulation of the Unfair Contract Terms Act 1977, not the Consumer Rights Act that we do next week. Okay, so I think at this point it's worth pausing and just to go over how you might write problem questions. Often we don't always spell this out in lectures, and I'm sure you have done it in tutorials, but it's worth recapping. I think a good method for how you might approach a problem question that I suggest that you apply through all of your work throughout law school. First, in a problem question, I think easy way to go through any answer is the IRAC method. So first of all, you should state what the issue is. So in this example, the issue would be whether or not Ms. Lestrange could have a claim for breach of contract if an implied term cannot be excluded. So the issue is she wants to claim breach of contract, and the answer turns on whether there's an implied term that is breached. Another way of approaching the issue part is you ask who wants what from whom on the basis of what law. So who wants what from who on the basis of what law? And that should always be spelt out as the very first thing if you're answering a problem question, and phrase it in terms of the claim. It's possible that Mr. Strange could have a claim for breach of contract if the implied term for satisfactory quality of the products can't be excluded. And then the second thing that you do, and I think this is very important to keep a good structure, is you state what the rule is. So here we've got the rule from the Sale of Goods Act 1979. Section 14.2 requires that goods are of satisfactory quality, and then the Unfair Contract Terms Act 1977 prevents any exclusion of these terms unless they are reasonable. And what you want to do is you want to go on to spell out the legislation, explain any case law. You could explain George Mitchell and Finney Lockseed's, a short explanation of the facts, usually 1 or 2 sentences on the main case. Should do it. Don't go into long descriptions of the facts. Keep it short, keep it succinct, keep as much detail in as you can, and then quote the case judgments, quote the statutes. That's really important to show you know what you're talking about. Good answers always quote things, just like in a real judgment by a court. So that's what you want to do too. You want to write like a judge. And then, after we've explained the rules, we apply them. So, when you're writing a problem question, you break up separate claims. So you don't do it all in one, but after you've stated the basic rules, apply them to the facts at hand. And here we've got a really simple problem question. So, you could apply it in the following way. So here the machine was not of satisfactory quality and bargaining power is very unequal, and so therefore you conclude it follows that there is a breach of contracts and the exclusion clause is invalid. So there you go. That's how you write problem questions. I would strongly recommend that you apply this or a similar method into everything that you do. Then you've got essay questions, and this is different. I think that there's 3 main things that you need for essay questions. This is, broadly speaking, substance and structure and style. The substance is the law. The structure is, having a clear delineation of the different things that you're talking about through your essay, grouping ideas in a coherent way. And style is, your flair in writing and creativity, the stuff that's added on top. So I think that there's a good guide to how to write a persuasive argument in an old Roman text, an old Latin text called Rhetorica ad Herennium. So this is literally how to do rhetoric for Mr. Herennium. Probably written by somebody like Cicero. We don't really know who anymore. But he said, or perhaps she said, that there is, the author of this said that there is a good pattern for any persuasive argument. And broadly speaking, it has 3 main parts. You introduce the beginning of your argument by setting out the importance of your topic or the background. And then summarize what you're going to say afterwards. Summarize the main steps of your argument. So sometimes you might be taught at school that an introduction is to restate the question. Forget that. That's wrong. What you want to do is you want to introduce your argument, what you're going to say, and you want to say the main things that are going to follow. That's literally what an introduction is for. Set out the general context, why this matters, and then get to the main points that you're going to follow. I always think that 3 main points are pretty good as a guide for most things. Sometimes 2 is better, sometimes 4 is better. But that's what you should be doing in an introduction. Short, succinct, to the point, stating what your argument's going to be. In the body of the essay, which is most of it, set out the background of the law or the argument that you're making. Second thing, you could set forward your positive case. Third thing, anticipate and rebut counter arguments. So depending on what your argument would be, you're saying what is the context for the thing that you're arguing about. Second thing is you're putting forward the reasons for why your arguments are right. And then third thing is you're anticipating and rebutting counter arguments. You could do it in a different way. You could say, well, I've got three main points I'm going to talk about: consideration, estoppel, and certainty, or whatever it is. But have a structure. So it doesn't matter necessarily what your structure is, but you've got to have a structure. And always, when you're doing law, reasons and examples through case law and statute are what matter most in persuading your audience, persuading with evidence. And the third thing is that you conclude, and a conclusion is not just to sort of restate what you've already said, although you can do that. And don't start off a conclusion with "in conclusion" or "to conclude," because that's boring. What you should do is you should plead the urgency of your case, why it really matters. And there you've got a persuasive argument. Goethe, in Faust Part 1, I think put it quite nicely, saying that, I think this was the devil to Faust, will teach you that your process of thinking, instead of being like eating and drinking, spontaneous, instantaneous, and free, must proceed by 1 and 2 and 3. So, says it all perfectly well there. Three main points is always a good way to approach how to make an argument. And by the way, Goethe's Faust involved a very unfair term. As you might know, Faust says to the devil that if the devil is his servant in this life, then Faust would commit to being the servant of the devil in the next life, which, of course, is quite unfair because that life, the afterlife, lasts for a lot longer period of time than this one does, in return for a drop of blood and a signature. So nice unfair terms issue in the classics. Okay, now we get to your homework before we take a break. So I asked you at the end of the last lecture to send in examples of unfair terms that you had found. And quite a few of you did. Many of you found the same one, which comes up every year. Amazon Web Services has, in section 4210, buried in its service terms, that platforms cannot be used for life-saving or safety-critical equipment like military arms, and adds that this restriction will not apply in the event, basically, of a zombie apocalypse, where there is a viral infection transmitted by bites or contact with human bodily fluids that causes human corpses to reanimate, and everybody turns into a zombie. Which is kind of funny, like, Amazon is excluding liability for zombie apocalypse, and maybe contract lecturers around the world are sort of pointing to this as an example of unfair terms. But what's really funny about this is I reckon that if you look through Amazon's terms and conditions, particularly to its small business, you're going to find unfair terms all over the place. And the reason why it might have entered not just as a joke that it excluded use of its services to battle the zombie apocalypse is it might want to be distracting from other unfair terms. Another example that I've been sent in is even closer to home, and probably the King's residences that you've been that you're in right now. So if you look at your own contract terms for your accommodation, I think that you'll probably find clause 3.2 says that Kings, because your licensees has the right, or people from Kings have the right to enter the accommodation at any time, including during the night, without giving you notice. Now, this seems, and it seemed to the student that sent this in, to be quite an unfair term. What about your right to privacy? Why shouldn't there have to be reasonable notice before there's entry into your accommodation which you've paid for? This is in the contract, but does it conflict with the human right that everybody has to privacy and exclusive protection of your home. So that, I think, is a potentially problematic term in a contract that could be subject to judicial review, particularly under the Human Rights Act. A personal favourite of mine is this one, which is just straightforwardly danger, private lot, outsider, no enter. If any accident, take yourself. So I think that this one would fairly and squarely be an unfair term under the Unfair Contract Terms Act, Section 2.1, if it was trying to exclude liability for occupier's liability or occupier's negligence. But I have to say that most of you did not send in terms. And so you know who you are. And if you failed to send a term in to me, I am now going to vary the terms of the lecture as I said, and you signed up to. So I've reserved the right to vary the terms of the lecture to require now a 150-word essay on how these lecture terms apply to you and why they are fair based on the law that you've learned. I strongly suggest that you pay attention and this time do your homework and send it in to me, because if you don't, I may use my discretion under the terms of the lecture to not give you the next lecture. As the lecture term says, it's totally at my discretion. So if you want to keep on doing the Consumer Rights Act next week, then you better do your homework, and I'm going to email you with further instructions. Okay. Let's take a short break for 5 minutes, and then we'll go on with the rest of unfair contract terms, or the Unfair Contract Terms Act. So I'll see you in about 5 minutes. Good. Back. And can you hear me again? All back on track. And also, does anyone want to ask any questions? Chuck them in the chat if there's anything that you'd like to ask from the previous part. Not about the homework. Thanks, Carla. Not about the homework, but anything. Does anybody have questions about the law that we've done so far? All right. In that case, we will move on. But I'd like to say something else, a public service announcement. And I'll talk about this perhaps a little bit more next week if we need to, which is that a strike has been called by the University and College Union, which represents all academic staff. And so this likely means that the week before Reading Week will not see any teaching. So unfortunately, that means my last contract law lecture, and also the week after Reading Week may well mean strike action as well, unless there is an agreement between the union and the employers about pay and equality and pensions. So, unfortunately, this is very likely to disrupt contract lectures, most first year teaching. I expect that probably more than half of subjects are going to be affected, more than half of teachers. Just so that you know what the dispute is about, you will have probably seen some strike action in December. The dispute is about teachers suffering pay cuts of around 20% since 2010. So people's pay has been progressively going down in real terms at the same time as your tuition fees have been rising. So if you're a home student, it's gone from £3,000 to £9,000. If you're an international student, it's more than doubled as well. Escalating fees up to I think around £24,000 now. No, it's not only contract law, Felicia. It's pretty much every subject could be affected if the members of academic staff are members of the union. So pay cuts is one thing that is the dispute is over. So your fees going up, but investment in your teaching is going down, and teachers' pay is going down. The gender and ethnicity pay gaps are not being resolved, so we've got huge disparities between the amount that men and women are paid, including in the law school and across many faculties, and on the basis of race or ethnicity. There's big pay gaps between white people and people who are black and brown and Asian, and the union says that this has got to change, and that we need to have a real commitment to equality and anti-discrimination. And the university employers are failing to bargain to stop it. And the third main thing that you'll hear about, and it gets a little bit tricky, but it's not really, is that the university employers want to cut the pension by 25%. So after all of the work that everybody has gone through the pandemic, after all of the disruption that you've had as students through the pandemic, university employers want to do it again by shutting down the universities, by threatening a pay cut and pension pay cuts of 25%. So those are the reasons that there is strike action. So, as I say, it's the week before Reading Week, probably the week after Reading Week, unless employers get around the bargaining table and stop cutting people's pay and pensions. So if you don't want that to happen, then the best thing to do is get involved in your student societies and call for a stop to the pay cuts, an end to the inequality, an end to the discrimination, an end to the pension attacks. write to the principal of the college and say that they should negotiate, and talk to your friends and colleagues to inform yourself about what's happening, because you're very likely to hear a lot of misinformation about what the issues are in the strike. Often you're just not told what's happening, which I think is the reason why it's important to tell you now. So discuss it as much as you can. And I'm happy to answer any questions, including next week. Reading week is in a couple of weeks' time. Okay, but now back to unfair contract terms, and we're going to walk through the rest of the Act. Often this is seen as a little bit complicated, but it's really not. We've just got some main sections in the Unfair Contract Terms Act, and they all do different things. We've got one for personal injury and safety and death. Then we've got this one. We've got Section 6 for the Sale of Goods Act. Then we've got this one, Section 2.2 for property loss. And then we're going to see one on breach of contract. So we just need to go through those. And then there's Section 13 on anti-avoidance measures. So first of all, Section 2 says that in the case of other loss or damage apart from death or personal injury, a person cannot so exclude or restrict his liability for negligence except insofar as the term or notice satisfies the requirement of reasonableness. So for property damage, you can have restrictions on liability exclusions for property damage, but they have to be reasonable. And so then again, we go to the reasonableness test. And then we've got Section 13, which is the anti-avoidance measure. And so, the upshot of this section is that if something has the effect of exempting liability against a victim of property damage or breach of contract or otherwise that we'll see in a second, then the verbal form of the clause is irrelevant. What matters is the substance of what a clause does. Now, this is not entirely undisputed, this interpretation. Coote, in a book called Exception Clauses, argued that if a clause defines a contract's primary obligations restrictively, so it purports to never allow a duty to be owed, it's not really an exemption clause, but is a duty-defining clause, right? So, liability could be preempted rather than, there being any exception or exclusion clause. But this sort of approach to construction of what counts as an exception clause is rejected by the 1977 Act because Section 13 looks at the substance and not the form of an obligation. It asks what obligations would exist but for the potentially unfair term or the potentially objectionable term. So this is what it says in the provision. To the extent that this part of the Act prevents the exclusion or restriction of any liability, it also prevents A, the making of liability or its enforcement subject to restrictive or onerous conditions, like if you want to bring a claim, you've got to give me £1 million. I mean, that's a stupid example, but something like that. If you want to impose onerous conditions on enforcing the unfair terms legislation, then Section 13 says, you can't do that. Then B says excluding or restricting any right or remedy. So an example of this is a couple of lectures ago, I told you about the Canadian case of Uber and Heller, where Mr. Heller wants to claim the minimum wage and social security protection in Canada, and Uber tells him, well, you've got to go to the Netherlands to arbitration there if you want to enforce your Canadian labour rights. So this would be an example of restricting any right or remedy by making it harder. And C says excluding or restricting rules of evidence or procedure. And to that extent, sections 2 and 5 to 7 also prevent excluding or restricting liability by reference to terms and notices which exclude or restrict the relevant obligation or duty. So, it doesn't matter if it's a duty-defining clause or if it's, phrased as an exception or an exclusion clause, Section 13 catches it. Okay, so let's see some examples of this. Section 2.2 on property loss or damage, operating together with Section 13. First main case is called Smith and Eric S. Bush. So really easy set of facts. Mrs. Smith buys a new house with a loan from a building society. The building society gets Eric S. Bush to do a survey of the property to check whether the building is in good shape, whether it needs any repairs, and it says the house is fine, it doesn't need any essential repairs. Now, Eric S. Bush, the surveyor, does not contract with Mrs. Smith, who's buying the house. It contracts with the building society. But after the surveyor does its report, it disclaims the accuracy of the report to anyone who might read the report. Everyone knows that it's going to be somebody like Mrs. Smith, the home buyer, that's going to read the report. But Eric S. Bush is saying, I don't even have a duty in the first place. It's a duty defining clause. I don't owe any duty to anybody else who reads the report. So after Mrs. Smith buys the house, very sadly, the chimney collapses because there's a structural defect, and this destroys the roof. So bam, the chimney goes through the roof. Eric S. Bush, the question is whether Eric S. Bush is liable under the Unfair Contract Terms Act Section 2.2, because this is property damage, and Section 13, because this is purporting to exclude or restrict liability for property damage. The House of Lords holds that the surveyor is liable. Under Section 13, the way that the contract is framed is an attempt to preclude the duty, and it has no consequence. It's also caught by Section 2.2. This is property damage, and the exemption is unreasonable under Section 11 because Eric S. Bush is better placed to get insurance than Mrs. Smith. So same thing as in George Mitchell and Finney Lockseeds. Just like the seed company can get one insurance contract when the farmers, would have to get multiple insurance contracts. Here, the surveyor is, dealing with lots and lots of different home buyers. And so it's much better for the surveyor to get one insurance contract to cover all of their business operations than it is for all the home buyers to get individual insurance contracts. In the reasoning, Lord Griffith says the following. Everyone knows that all prudent and professional people carry insurance, and the availability and cost of insurance must be a relevant factor when considering which of the two parties should be required to bear the risk of a loss. Insurance matters. We're dealing in this case with a loss which will be limited to the value of a modest house and against which it can be expected that the surveyor will be insured. Bearing the loss will be unlikely to cause significant hardship if it has to be borne by the surveyor, but it is, on the other hand, quite possible that it will be a financial catastrophe for the purchaser, who may be left with a valueless home and no money to buy another. Right? So this is a major purchase in somebody's life to get a home. If the chimney collapses, you're completely messed up. And so that's a big problem to put all this risk on the very small shoulders of the home buyer, but the broader shoulders of the professional surveyor are better placed to cover, especially because they can just get one insurance contract. So there we go. That's another leading case of property damage under Section 2.2 and Section 13. Next case is called Philip Products Limited and Highland in the Court of Appeal in 1984. So here we've got another case of property damage. Hampstead Plant Hire Co. Limited hires out a JCB excavator. So this is one of these yellow kind of tractor things with mechanical arms. And with the JCB excavator, it also hires out a driver who's called Mr. Highland to Phillips Products Limited. Standard terms and conditions are provided in this deal, and Condition 8 of the standard terms says that Mr. Highland is considered Phillips Products employee. So Mr. Hyland is considered to be the employee of Philips Products. So basically, if anything goes wrong, it's Philips Products' problem, not Hampstead Plant Hire, who is giving the JCB excavator and the driver to the hirer of the machinery. Very sadly, Mr. Hyland crashes into a wall. This causes damage, and the question is whether Hyland is liable. Beg your pardon. Hampstead Plant Hire is liable for Mr. Hyland, or whether it is indeed Philips Product problem, as Condition 8 suggests. Lord Justice Slade in the Court of Appeal says that Condition 8 is in effect an exclusion clause. So even though it's in the form of being duty defining and attempts to shift responsibility onto Philips Products for whatever Mr. Hyland does wrong, it's caught by Section 13. But then we still go on to the question of whether it's reasonable under Section 2.2. And the answer the Court of Appeal gives is no. It's unreasonable because Hampstead Plant Hire is better placed than, again, Philips Products to get insurance for such short hire jobs. Okay, so there we go. Condition 8 is struck down. But then, and this might seem slightly contradictory, we have a different sort of outcome on similar sets of facts, but not quite the same, in another Court of Appeal judgment on exactly the same standard contract term in a case called Thompson and T. Lohan Plant Hire Limited. So here, T. Lohan hires out a JCB excavator again and a driver again, this time called Mr. Hill, to JW Herdis Limited. And the same Condition 8 said that Mr. Hill would be considered JW Herdis's employee. Very sadly and tragically, Mr. Hill ran over and killed another worker called Mr. Thompson. And so Mrs. Thompson, the widow, sues T. Lohan Plant Hire Limited, and she wins compensation for the unlawful killing of her husband. And then what happens is T. Lohan Plant Hire seeks to get money back from JW Herdis Limited. And so the question is, well, who has to pay? Now, this Court of Appeal holds that the point, and we're not talking about property damage now, we're talking about personal injury in this case, but the point of Section 2.1 is to protect the victim. And because Condition 8, has passed liability to JW Herdis, but operating between two businesses, and the victim is compensated anyway, Condition 8 is not to be considered an exemption clause because the person who gets killed and his widow has been compensated. And so Condition 8 is simply allocating the contractual risk between two businesses and should be considered effective. Mr. Hill is to be considered JW Herdis's employee. Now, this is a result which, you can sort of see the reasoning, the victim is compensated, but, even if you agree with the result, is it reasoned in the right way? Should it be the case that we say the same as the Court of Appeal? I mean, why not say that it is an exemption clause, in effect, but we ultimately want to conclude that it's reasonable because there's just a contractual allocation of risk over who has to compensate, and the victim ultimately does get the money for the loss that is due. So I suppose we could argue about whether the Court of Appeal does the right reasoning, even if we think that it comes to the right judgment in Thompson. Okay, now on to another provision in the Unfair Contract Terms Act. The next major provision is Section 3. So we've seen death and personal injury in Section 2.1. We've seen no exemptions for the implied terms in the Sale of Goods Act under Section 6. We've seen property damage in Section 2.2. And Section 3 deals with liability for breach of contract. So this says that when somebody deals on another person's standard terms, so when it's the same terms used over and over again in standard form contracts, then there can be no exemption for liability for breach of contract under subsection B2B1, or for performing something different from what was reasonably expected, or performing nothing at all, unless the exemption or the limitation is reasonable. So if it passes the reasonableness test, then you can have it. But if it doesn't pass the reasonableness test, then you can't. So here's where we get to, I think a very clear case that contradicts the opinions of the Supreme Court in Bevis and Parking Eye. That the Unfair Contract Terms Act doesn't matter for small businesses; it's only really for consumers. Well, that doesn't really seem to be true in this case, if nothing else, called Time Load Limited and British Telecom PLC. So that's BT. So here the contract term from BT was that BT's clause said it could terminate at any time. It could terminate the telecommunication service at any time, and really for any reason. And the Court of Appeal was asked, well, is this fair? Because, if you're terminating the contract, you're not performing what is reasonably expected. The Court of Appeal and Sir Thomas Bingham, Master of the Rolls at the time, held that the term is unfair because it renders performance of a service which is very different from what was reasonably expected. You expect to get stable telecommunications connections, or think of, I suppose nowadays, stable internet, the main thing that matters. And something that is different from what is reasonably expected is actually being performed. And so Section 3 is not passed. And the term is unreasonable because here you've got a very big business, indeed a almost monopoly provider of telecoms at the time, that's British Telecom, dealing with a small or a medium-sized enterprise. And so the term is unfair. Another case on the same provision, Section 3, is called Stuart Gill and Horatio Meyer. Here Stuart Gill sold Horatio Meyer an overhead conveyor system, and Horatio Meyer was supposed to pay for it in installments. Stuart Gill's standard terms in condition 12.4 excluded Horatio Meyer's right to set off payments for the goods being defective. So, if this overhead conveyancer system, I guess it's like ropes and pulleys, and it sort of transports stuff over the heads of everybody in a warehouse. If it doesn't work, then one of the remedies that you might have in equity is that you don't pay for the service, right? If you're paying in installments, you can set off a certain sum of money for the thing not working. And condition 12.4 excludes the right to do that for the goods being defective. Horatio Meyer refuses to pay the last installment, and Stuart Gill sues and relies on condition 12.4, saying, you've got to give us the money because you can't just set off payments. Court of Appeal holds that Section 13 means that the condition 12.4 is in effect an exclusion clause. It's not just a simple duty defining clause. And it's caught by Sections 3 or 7, and it's unreasonable for the condition to operate. Again, you look at the bargaining power of the parties, insurance, all the rest of it, and it becomes unreasonable. Third case is called St Albans City and District Council and International Computers Limited. So this case followed the Margaret Thatcher government's desire to tax people simply for living. This was called the poll tax, and there were massive riots in Trafalgar Square that eventually led to the Thatcher government's downfall and the poll tax not being implemented. It was known as the community charge. So every adult person had to pay a tax just simply for being a person, the poll tax. Before this was implemented, lots of local councils who were going to have to collect the tax set up computer systems, or tried to set up computer systems to administer the taxation collection. Councils, including St Albans, and they bought computer systems to run it. St Albans bought one from International Computers Limited, and unfortunately, the one that it purchased failed. And so, in the collection of taxes, like the community charge, it didn't receive £1.3 million in payments. So, it sued International Computers for this money that it lost as a result of the failure of the computer system. However, International Computers' standard contract terms limited liability to £100,000 as a maximum. Question was whether this was fair. Justice Scott Baker in the High Court held that the limit was unreasonable under, again, Section 3, limitation of liability for breach of contract. The computer system doesn't work and you're trying to limit liability. Is it reasonable under Section 11 and Schedule 2? Well, the answer is no, because even though this is a public body, a local council, it's dealing with a big multinational computer corporation. And that computer corporation has much more bargaining power. So the bargaining power of the parties is taken into account into whether the term is reasonable, and it's not. So that's the third example. Fourth example, and I think, this one is going in the opposite direction, or gives us, an example of what the limit should be to the reasonableness test. Watford Electronics and Sanderson Limited. Sanderson here is a software supplier, and it sells Watford Electronics, which is a computer retailer, a computer system that also fails. The contract states that consequential losses are excluded. Can there be a claim anyway? Lord Justice Chadwick, who overturns the High Court judge, says that in circumstances where the parties are of equal bargaining power and they negotiate a price for the supply of a product under an agreement which provides the person on whom the risk of loss will fall, it seems to him that the court should be very cautious before saying or reaching a conclusion that the agreement is not fair or reasonable. Here, the Court of Appeal says, even though there's an exclusion clause for the computer system not working, they should be very cautious before overturning the contractual terms which have been set. If they've got equal bargaining power, leave it up to the parties. We don't need the courts to interfere into the terms of the contract. Whatever allocation of risk is in the contract among the parties, that is presumptively fair. And so I think that gives us a good point of principle, which is that the Unfair Contract Terms Act is really aimed at trying to regulate terms where people can't fend for themselves, where you've got parties of very unequal bargaining power. Another illustration of the operation of the Unfair Contract Terms Act, and this time connecting with the Misrepresentation Act that you saw last term, is in First Tower Trustees and CDS Superstores Limited. So here CDS claims that First Tower Trustees Clause 5.8 in its lease agreement was unfair. This excludes liability for misrepresentations. So remember, in Section 3 of the Misrepresentation Act, it says after Section 2.1 and Section 2.2 that say you've got a claim for damages for negligent misrepresentation. Section 3 says that exclusions of liability for misrepresentation are subject to the reasonableness test. So that's what we've got at issue in this case. In this scenario, First Tower Trustees said that there were no environmental problems in the warehouse that it was leasing out. But in fact, it was aware that the warehouse was infested with asbestos. So asbestos is that material that's used for fireproofing buildings. But if you breathe in the fibers, there's a very good chance that you will have a slow and painful death as the asbestos fibers lodge in your lungs, and then you get all sorts of horrible cancers and diseases that are very nasty. So the question is whether Misrepresentation Act Section 3 and UCTA Section 11 are engaged. Court of Appeal held that the misrepresentation could not be excluded, or liability for the misrepresentation could not be excluded. First Tower trustees would have been liable but for the exclusion, and the exclusion clause was not reasonable. And First Tower trustees is better placed to get insurance. So, straightforward resolution. Again, businesses, small businesses, medium businesses, making use of the provisions in the Unfair Contract Terms Act. Final provision to note in UCTA is Section 10, and this says that where you have contracts that take away rights in another contract, they have no effect. So, one contract over here can't exclude or restrict liability in another contract over there. An illustration or another extension of this principle is Tudor Grange Holdings and Citibank, which says that Section 10 doesn't apply to genuine compromises of existing claims. So if you get a settlement between two parties after they've been litigating, or before they go to court, or after an appeal, then settlement agreements aren't caught by Section 10. But otherwise, you can't exclude or restrict liability in one contract from another contract. It's just subject to UCTA as well. So to summarise the Unfair Contract Terms Act, number 1, Section 2.1 concerns exclusions or restrictions of liability for death or personal injury, and you can't do it. Section 2.2 says or concerns exclusions or restrictions of liability for property damage, and you can do it, but only if it's reasonable. And so then we go to Schedule 2 or Section 11. Third thing is breach of contract claims in Section 3. So if you're dealing on somebody else's standard form contracts, so that's a threshold requirement, then liability can be excluded or restricted, but only if it's reasonable. And again, Section 11, Schedule 2. And then there's Section 6, exemption of implied terms under the Sale of Goods Act or Supplied Goods and Services Act. They must be reasonable. Again, Section 11, Schedule 2. So that's the Unfair Contract Terms Act in a summary. It's really easy. And the reasonableness test, again in Section 11 and Schedule 2, takes into account the following factors: insurance, bargaining power, whether you've had an inducement, whether the terms are transparent, if it's reasonable to comply with the conditions, and if goods are made to order. But the two things, or perhaps three things, that you need to focus on are insurance, bargaining power, and transparency. Okay, so the last thing I want to talk about now is whether there's any room for reform of the way that we approach the legislation, and particularly how courts reason around the Unfair Contract Terms Act. Because remember, at the start, we've seen the Supreme Court doubting that the court should do anything unless Parliament has expressly told them to do so. And second of all, even when they've got legislation, they seem to be minimising the effect of the Unfair Contract Terms Act. They say that really there's nothing left to do for small and medium enterprises. It's mostly superseded, except for cases where we've got consumers, and we see that next week. So I think it's worth asking whether we should re-examine how courts approach these issues. In an article an article written about a decade after the Unfair Contracts Terms Act was introduced, Adams and Brownsword, Professor Brownsword, who I think still works at King's, argued that the case law had shown from UCTA and things like George Mitchell that trial judges were being left with very wide discretion, and this could risk overturning the terms of many commercial deals when the courts might not be so expert. The Unfair Contract Terms Act is inherently discretionary in the way that it had been interpreted, and maybe it wasn't a good idea to interfere too much with what commercial businesses are agreeing with one another. So foreshadowing what we saw a bit earlier, like in Watford, Electronics and Sanderson, don't interfere where the parties' bargaining power is equal. They favour that approach. Like Lord Wilberforce in Photo Productions or Justice Chadwick in Watford, they suggest that we leave those parties alone. But what happens where the parties don't have don't have equal bargaining power, and you've got big businesses dealing with small businesses? What should we do there? I think that's one of the unanswered things, and the Supreme Court seems to be suggesting, well, we should still leave them alone. And the court seemed to be suggesting an inherent skepticism, as I say, of doing anything at all, and not much principled framework is evident. So George Mitchell is saying, we just don't interfere with first instance judgments very much. We give them a lot of leeway. But what is the basis for reviewing whether or not there are unfair terms? We've got the reasonableness test, but can we give it more structure? I think that we could. If we approached it in the following way, what the Unfair Contract Terms Act is doing in a kind of backwards, roundabout attempt is it's trying to protect certain rights. And we could focus on what these rights are a little bit more clearly. If we were rewriting the legislation, what we might do is we might outline that people have a right to life and a right to health and safety. That's indirectly what Section 2.1 is trying to protect. A right to satisfactory quality in products and services, a right to fair dealing in good faith. We see that in Timeload. A right to fair competition, a right to conduct a business. We can enumerate different rights that are underlying what the Unfair Contract Terms Act is doing. And if there's an interference with these rights, instead of approaching it backwards with exclusion clauses, we could, and instead of the indeterminacy of the reasonableness test, we could adopt a proportionality test. So if contract terms disproportionately interfere with the exercise of rights, then we do the same thing as in human rights law. We ask, first of all, does a business have a legitimate aim in using a clause which might impact on people's rights? Is there a case of business necessity, fair profits, efficiency, and so forth? And then we could ask, is the exemption clause appropriate to get to the aim, necessary, and reasonable between the parties? This is the structure of reasoning that we use in human rights law. You should be doing that in constitutional law, if not already, then very soon. And this would give, I think, the courts a grammar or a method to approach unfair terms cases in a more sort of structured and less arbitrary way. Because at the moment, the courts seem to be saying, well, we don't really want to do very much with the Unfair Contract Terms Act, except these old cases. And maybe they would be less reluctant to do so if there was a more structured approach. Okay, so that's really the argument for today, and my conclusions are three main things. First of all, that fair terms are often about businesses surviving, especially in the face of monopoly power. And monopoly power has only been growing in the last few years, particularly in the pandemic. We've got the growth of enormous multinational corporations like Amazon, like Google, which routinely change terms and impose unfair terms on other small businesses or medium businesses. Google Maps, Amazon Web Services, the Amazon platform. But we've also got local monopolies, in the UK, British Telecom, BP. So the use of unfair terms really does matter for whether small and medium enterprises survive and thrive. And so we shouldn't be too skeptical about this legislation. It can be really important. In the cases where unfair term regulations save businesses include things like cases that we've seen, George Mitchell and Finney Lockseeds, BT and Timeloan, First Tower trustees. And it's clear, at least to me, that all of these cases are rightly decided, and they're not, as the Supreme Court has said, have been superseded. We shouldn't be skeptical about the use of the legislation. On the contrary, the court should be more aggressive in using legislation, if anything. But the third thing is that this is just a start. because unfair terms regulation is part of a much larger body of law on public ownership, regulation of monopolies, the regulation of competition and its enforcement. Unfair terms legislation is a baseline, the bare minimum of what we should be doing to create a fairer system of enterprise. And so courts should be construing the law openly and actively in light of this overriding policy objective, which Parliament seems to have set again and again and again in Acts of Parliament. We should be construing the role of the courts consistently with the goals that Parliament has set. Okay, so that's it for today. We will be doing consumer rights next week. However, you've got to do your homework. So I'll set, or I'll send around an email about. Or setting out a very short problem question of why the terms of the lectures apply to you. So stay tuned to that. And if you do your homework properly, I might use my discretion to send you the lecture for next week. Okay, have a very good morning. I will jump onto Teams now if anyone wants to talk, and have a good rest of the week. And yes, I will also put the PowerPoint slides on Keats. Thank you for asking, Caroline. I'll go and do that now exactly.